Taylor Schabusiness was found guilty yesterday. The jury deliberated for less than an hour. Earthquake again. I'm sorry, I have a dog underneath the camera right now. The jury deliberated for less than an hour, and they found that she was guilty for the murder of Shad Therian. Now, in Wisconsin, they do things in two phases, which I've actually never experienced or watched before in a trial, so it's pretty interesting. We did a phase 1 where it was a guilt phase, whether or not she's guilty. And now we are in phase 2. Phase 2 is where they find if she was basically insane or not during the time the murder had happened, and if she's, I don't know, I guess culpable. So she could either be sent to like prison or maybe like to like a mental facility. And so usually in trials that I watch, usually both of those are kind of like combined into one, where, you know, you have psychologists, psychiatrists, they both testify, you know, do the evaluations and stuff like that. But at the same time, you also have the detectives testifying, talking about the evidence, interrogations, and that's usually combined into one. And then like for the Letitia Stock one, for the example, right? She was playing not guilty by insanity. And so that was all done in one go. So kind of interesting to see how, you know, different states do different things. But we're going to start with the phase 2 right now. And again, they're going to be doing the opening statements again today. So I think it's going to be pretty short, actually, for this entirety. So they're going to do the opening statements again. And then what else is there? Opening statements. Oh, and this time the burden is on the defense to prove that Taylor was maybe had a mental defect at the time that the murders happened. So they're going to present first, and then afterwards the state's going to go, and then maybe there's like rebuttal or something like that. But hello, guys. I hope you guys are doing well today. And let's... Oh, wait, hold on a second. Oops. Did it go live? I just got a notification that we just went live. Oh, no, I don't know. We might have just missed all that. Well, I recorded it. So if you missed it, it'll be in the recorded version. If you're on the live stream, we're watching the Taylor Schabusiness trial. Hi. Hello.
The defendant has been found guilty of first-degree intentional homicide, mutilating a corpse, and third-degree sexual assault. We will now proceed with the second phase of this trial. During the second phase, you will be asked to determine whether the defendant is not responsible by reason of mental disease or defect.
Boost the audio
Before
bit.
you may find the defendant is not responsible for the criminal conduct, the defendant must satisfy you to a reasonable certainty by the greater weight of the credible evidence that at the time the crime was committed, the defendant had a mental disease or defect, and as a result lacked substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of the law. This issue will be presented to you in the form of two questions. First, at the time the crime was committed, did the defendant have a mental disease or defect? Second, as a result of the mental disease or defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of the law? You will be asked to answer the second question only if you answer the first question yes. If you find the defendant is not responsible...
I have a feeling this might all be done in one day, by the way. Possibly like a day and a half, but it's possible this could just wrap up today.
...for the criminal conduct, the defendant will be committed to the custody of the Department of Health Services and will be placed in an appropriate institution unless the court determines that the defendant would not pose a danger to herself or to others if released under conditions ordered by the court.
Oh,
the only
man.
issue at this second phase of the trial is the defendant's mental condition at the time of the offense. The lawyers will now make opening statements. The purpose of an opening statement is to give the lawyers an opportunity to tell you what they expect the evidence will show so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. And ladies and gentlemen, because this phase of the trial, the burden of proof shifts to the defense, the order of questioning and presentation will change, and Mr. Freilich will go first. Mr. Freilich, are you prepared to make your opening statement?
Yes, I am, Your Honor.
Mr. Freilich, welcome back.
Mr. Saunders, prosecutors for the state of Wisconsin. You're going to hear some testimony in this case from the defense expert, Dr. Diane Linton. She's from the Menasha area. She's a PhD. She's a forensic psychologist. You're going to hear testimony from the state doctors as well, Dr. Matthew Seipel and Dr. Christina Engine. The burden does shift to the defense in this particular case. We're in phase 2 now, and the burden shifts to the defense, to me, to ask you to consider.
And I personally find phase 2 to be more the interesting part of this trial. Phase 1, it was like we knew she did it. She admitted to it, and it was just like gruesome. But phase 2 is like kind of interesting because, you know, we get to hear about, you know, what the psychiatrist thinks about her and the evaluations and stuff like that. So I personally think this is the more interesting part.
Whether the defendant, Taylor Denise Schabusiness, is responsible or is not responsible by reason of mental disease or defect.
Like, was it
and
drugs,
Wisconsin law,
or was
under
she
Wisconsin
suffering from
statutes
something?
971.15, does require the defense to satisfy you jurors to a reasonable certainty by the greater weight of credible evidence that at the time the crimes were committed, which was February 22nd of 2022, that Taylor Shabizis had a mental disease or had a mental defect, and that as a result, she lacked the substantial capacity either to appreciate the wrongfulness of her conduct or to conform her conduct to the requirements of the law. So that's packed with a lot of information that you're going to have to consider. I did tell you yesterday that you're kind of like analysts. You're going to have to listen to the testimony, listen to the facts, assess the credibility of witnesses, assess the information that you're receiving, and then you'll have to make some decisions and considerations on these.
Do I think should be judged insane and responsible? So I've already listened to a little bit of this, but I had it in the background. So I was like listening to bits and pieces here and there. From what I've heard, I mean, maybe when I listen to it again, I'll change my mind. But from what I've heard so far, it just seems like it's mostly just like all drug related, like the stuff that she was experiencing, the possible psychosis or the hallucination and stuff like that. And that like she actually started experiencing those once she started doing meth. But let's listen.
Important legal issues. The defense did retain Dr. Diane Litton. She interviewed Taylor Shabizis. We believe that the evidence will show that she did a thorough evaluation of Ms. Shabizis' mental status.
Good, he's speaking to the mic
You will
today.
hear about Dr. Litton's extensive experience in the field of psychology. When you have experts, you kind of heard from other experts, they have a resume or a CV. In the field, we say CV, curriculum vitae. It's a list of their experience in training and education. And you're going to hear that Dr. Litton has been a psychologist since 1993, that she has extensive experience, that she has approximately 3,000 hours of postdoctoral training, that she conducted hundreds of forensic evaluations and GI competency evaluations, things of that sort. You will hear testimony that she worked at Mendota Mental Health Institution.
And just a spoiler alert, I think the two witnesses that testified today, was there more? Her dad for sure testifies, and this doctor. I don't know if there was a third witness.
Here in Wisconsin?
I think just these two.
That she looked at many different evaluations performed on Taylor Shabizis, including from Dr. Tracy Lucetta, Dr. Matthew Seipel, Dr. Christina Engine, Dr. Deborah Collins. And you will hear that Dr. Litton, we believe she'll testify that she looked at a whole myriad of records, including jail records, mental health records, a court order, an order for civil commitment, mental health order, an order to take psychotropic medications, basically a medication order. She will, I believe, testify that she reviewed Nicolay Psychiatric Center mental health records from Brown County. She will talk and testify about her contacts with Ms. Shabizis on the different occasions that she met with her, one being a situation where a chair was thrown by my client at her before I got involved in the case. She will testify that she did have another interview with her at the jail, and she asked me to sit in. So you're going to hear about all of her findings, her observations, and her opinions in this particular case. We believe that she has extensive experience. She's been in this field for a very long time, and that you need to pay close attention to what she says and give her opinions strong consideration. Give it due weight. And we believe that her testimony will be that she's of the opinion that Taylor Shabizis does qualify for the NGI plea based on her diagnosis of a serious mental disorder. And that she has some other opinions, and she'll tell you about those when she testifies. You will hear, I believe, testimony from my client.
So you're going to hear NGI a lot. I don't know if he already specified it, but he might have. NGI is just a short term for not guilty by insanity.
My father, Arturo Coronado. And I believe that he will come here. He's been summoned by the defense by subpoena to answer some questions about his daughter growing up, how she was,
her dad is in jail
what kind of issues
for.
or problems did she have, what kind of mental health issues, and what he did to try and help her get treatment.
Arturo Coronado, let's see.
You will hear from Dr. Litton about my client's mother, that she lost her mother at a young age, and that was a pivotal event in her life. Dr. Litton will also provide some testimony about the fact that she believes there may have been a budding personality disorder, and that she saw a really disturbed teen when she assessed all of the school records. She looked at all the school records and did a table or a chart. She looked at the mental health history. She did a one-page chart on that. The burden of proof in this case does rest with the defense on the NGI issue. I think that the testimony from all of these different professionals, these different doctors, these psychologists who talk about behavior and things of that sort, you can hear their testimony about all of the different problems, all of the different mental health issues, all of the different behavioral issues that Taylor Shabizis had growing up as a kid, as a youth. She had a lot of obstacles that she had to face growing up. We believe Dr. Litton will also provide some testimony about my client's prior treatment with antipsychotic medications. She will testify about my client going off these antipsychotic medications, sometime after her inpatient treatment in 2021. And Dr. Litton will set up and provide the background history and information on Taylor Shabusiness's life and upbringing. So the defense does have the burden of proof on this issue of whether our client is responsible for these crimes. But we believe that the testimony and the evidence will show that at the time of the offense that she did have a mental disease or defect. We believe that the information and the testimony will show and hopefully lead to you to conclude that she lacked the substantial capacity to appreciate the wrongfulness of her conduct or to conform her conduct to the requirements of the law. And what I ask is that you just sit back, carefully listen to what these experts have to say, and then render a fair and just result. Thank you.
Hey, that's her defense lawyer. Next, we're going to have the state that's going to go up there. And honestly, when her dad testifies, though, I mean, we get like some background information, but in my opinion, not really that much.
Mr. Saunders, are you prepared to go?
No, this is not the sentencing. Oh, sorry. This life. So Wisconsin does things very differently. And it's something that I learned recently as well. So they actually do their trials in 2 phases. So you know how like we're used to watching, like, say, for example, like Letitia one, right? Where it's like it's one trial and they can either say guilty, not guilty by insanity. They could say or just not guilty, just rent normally. But in Wisconsin, it could be divided up into 2 trials. So for Taylor Shabusiness, they've already deemed that she's guilty. The jury already found her that. But right now, they're doing a second phase of the trial where they're going to do the opening statements again. This time the defense goes first because it's their burden to prove that Taylor Shabusiness was basically mentally insane at the time the murders happened. And the state's going to argue that she wasn't, that she was probably just on drugs or something like that. But yeah, so now we're in the phase 2 of trial. We're not at sentencing yet. So this is the part where they kind of figure out if she's going to go to like a mental institution, get treatment, and then maybe one day get released into the public, or if she's going to be sitting in prison for, however many years she's sentenced for, or the rest of her life.
Hi.
Go ahead.
Good morning. So
Very
I said
interesting.
in opening Monday that this case is about choices and responsibility. This is what we're referring to, right? The responsibility phase is what we're here for now.
Yep.
Essentially, you're being asked, what was the defendant's mental state at the time of the offenses for which she's convicted, and whether she should be responsible for that. Let's address the obvious.
Okay.
What Ms. Shabusiness did to Shad is disturbing. It's conduct we don't see often. It's conduct that you may hear about and think, my gosh, that person must not have been in the
And I want to say, listen carefully to his words, because I think he does a pretty good job at kind of explaining the confusion that we all have, right? So the confusion is that, like, oh my God, like someone who like did something this disturbing, they must be mentally insane. They must be mentally fucked. And there's like, I can't imagine like a regular person doing this. But the way that he explains it, it's like, could be drugs, could just be that, she's still responsible for it. So I don't know. I like the way that he explains it. I think he does a pretty good job.
in their right mind when that happened. I'm not going to sit here and try to convince you otherwise. But you've already carefully listened to the evidence and followed the law that the judge gave you. And you'll do so going forward as well. Because you will be told what a mental disease or defect is and what it is not. A mental disease is not antisocial conduct. It's not conduct brought about by use of a controlled substance, a temporary mental state caused by a controlled substance. A person is not mentally ill just because they commit something that's unnatural, that's so enormous, that just is beyond comprehension, right? You'll be instructed that those are not mental diseases or defects. So as disturbing as the conduct you already heard about is, and may be, that's not where the analysis ends. You'll hear from several experts. Defense already went over Dr. Litton and her qualifications and how she supports Ms. Shabusiness's NGI plea. But you'll also hear some issues with Dr. Litton's methodology, her analysis, and ultimately her conclusions. The state will call several psychologists of its own, both of whom were actually court appointed, not by either party, by the court, when they did their analysis and meetings with Ms. Shabusiness. Dr. Matthew Seipel will talk about some of the issues that he had with Dr. Litton's methodology and her conclusions. He'll testify about those. You'll also hear from the court-appointed expert, Dr. Christina Engman. Again, came here on a court order, not retained by either side, and she'll tell you that she does not believe Ms. Shabusiness is suffering from a mental disease or defect, or that she was unable or lacked substantial capacity to conform her conduct to the requirements of law or appreciate the wrongfulness of her conduct. Okay? So you'll hear from a variety of witnesses, some of whom are experts, some of whom are lay witnesses or civilians. You'll hear about, and you've already heard about, confounding all of this is the defendant's drug use immediately before the offense. We've all heard about that. Defendants admitting that and acknowledging that. Mm-hmm. You'll hear about how methamphetamine has those effects, has effects of psychosis, that has that result in people. And again, It's not a mental disease or defect if you're using controlled substances and it causes that result. So you'll hear from these experts and witnesses, but ultimately, in our state, whether somebody is suffering from a mental disease or defect is a jury determination. It's up to you, based on the facts and opinions that you hear. Certainly the opinions of the experts will be valuable for you, but you've already heard all the evidence. You know more about this case than any of these experts likely do. You heard testimony about Ms. Chavis's mental state both before and after, in close proximity to the offenses that she's convicted of. You've heard her friends, her roommate.
Like, I think for sure she definitely has like some sort of like mental issues, but like I think she was still responsible for the crime. But, you know, like I said, I was listening to the testimonies in the background for today's trial. So I'm going to listen to it again with you guys and very closely.
Officers who had contact with her, Mr. Hendricks, Ms. Pakinich, described their interactions in close proximity to this offense and reported nothing out of the ordinary, some of whom are her friends who've known her for quite a while. Mr. Gannon, Mr. Tomes, you already heard about their observations of the defendant. But more importantly, you saw the defendant's own words. Hours after all of these offenses occurred, really close proximity. You saw her be able to recall, be able to talk about it, and more importantly, you saw her mannerisms, how she was talking about it. Did not appear anyone was suffering under some manic episode. She's calmly talking about it with officers, providing information that is consistent with everything they're seeing. What does that indicate? She's aware of what's going on. She remembers everything. This isn't somebody who is not appreciating what happened. So that's why we call all these experts, but ultimately, at the end of the day, it's a jury determination. It's a factual issue for you. And the state believes that when you hear all that evidence and consider the evidence you heard in the first phase, that you'll find the defendant has failed to meet her burden.
Hey, Vicky.
That
Hey,
she should
Kim.
be held responsible for the conduct that she's convicted of and what she did to Shad.